Oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning, everybody. Please be seated. Welcome to the United States Court of Appeals for the Fourth Circuit. We have one case on for argument this morning. That's not typical, but glad to have you this morning. It's 24-1374 Sugar versus Burnett. Mr. Sasser.
May it please the court, Travis Sasser for myself and Christine Sugar. We're asking this court reverse the bankruptcy court for dismissing Ms. Sugar's bankruptcy case with a 5-year bar to refiling and sanctioning me for violation of a local rule of bankruptcy procedure that related to selling her residence. We believe that in the face of the bankruptcy code controlling authority, that controls over the local rules and that the local rules must yield. I have 5 points today. First, the local rule is invalid. Secondly, that the local rule was not violated. Third, that the local rule was not objectively or subjectively violated. Fourth, that there was no harm associated with the violation. And finally, that the trustee's motion to dismiss was untimely.
So I certainly want you to argue those points, but let's just assume, to start for the purposes of argument, that we disagreed with you on your view of the bankruptcy law. So in that circumstance, as to your client's dismissal with prejudice, what other arguments did you make as to why the bankruptcy court and later district court's decisions should be set aside as to her?
As to why her case should not be dismissed?
Correct.
Well, actually, I think we made all of those arguments at the bankruptcy court level.
Right, but let's assume we don't agree with you on that.
That
Is
the
there
property-
something else?
Your position is that the property is still property of the bank?
I don't have a position, I'm just asking questions.
Okay, well, I would still say that even if we took the district court's opinion, it seemed like the bankruptcy court and the district court were both saying, actually, despite the vesting and despite what the plan says, the property is still property of the bankruptcy estate. And our argument actually would still hold up relative to the fact that the local rule is still invalid because it violates actually the way that the bankruptcy code and the rules procedures work for selling estate property. It's still problematic. But also there was absolutely no harm done because if it was estate property, both of the trustee, the holders of unsecured claims, anybody who wanted to could try to modify the plan, which is all that is actually what happened in this case. Is they tried to modify it, and the bankruptcy court could have chosen to either dismiss the case, which is what actually the court chose, or to allow the trustee's modification. Ms. Sugar had $63,000 on hand at the time of that modification hearing.
I thought you told the bankruptcy court that when faced with that option, that you don't want it.
Well, the reason we declined that was because we were fighting the substantive aspect of the modification. I think the record in the case and all the pleadings show that just at a substantive level, we didn't agree that there was a substantial or unanticipated change of circumstance, and therefore we wanted to proceed on the modification.
All right, let me try to go more directly to what I'm particularly interested in. So again, assuming we disagree with you on the merits of your bankruptcy law claims, Ms. Sugar testified on several circumstances that she did what she did because you told her to.
Right.
Which would be an advice of counsel defense, which the court is at least required, I think, to consider. So what I'm asking you specifically is, where did you argue to the bankruptcy court or the district court that an advice of counsel defense holds her harmless in effect in terms of the dismissal?
Well, I think that the position that we took was that we believe it's an objective standard under Taggart. So in other words, in some ways what Ms. Sugar, I think the advice of counsel was a very small part of our defense. I think the biggest part of our defense is that objectively, which is what Taggart v. Lorenzen would say, is that objectively, neither her or I thought that the local rule was being violated. We actually thought.
Well, she didn't think it was being violated because you told her it wasn't being violated.
I think that's more or less correct, or at least there was no mention that the local rule was being violated, because I didn't think it was, but I don't think what I subjectively thought, which I very much did believe and still believe, is that the local rule was not violated.
So can I ask you about that? So perhaps maybe in isolation, but for what had happened in the past, that might make some sense, although I think there's a better way of going, of making the point rather than simply, at least as the bankruptcy court and district court found, flagrantly violating the rule and then arguing against it after the fact. But you had made this very argument in a different case, in the Pulliam case, right? A different context, but you had made the same attack on the rule, and this very same bankruptcy judge had rejected your view of the rule. So what are we supposed to do with that?
Well, I don't think very much. A couple things about Pulliam. I don't think that we attacked the local rule, by the way. We tried to understand the scope of the local rule.
Well, no, you inserted you inserted an exception in the plan, essentially saying, local rule be damned, I don't agree with it. This plan is not going to conform to that rule. And the bankruptcy judge said, no, that's wrong. So you were on notice, weren't you, that at least the bankruptcy court understood that rule to be enforceable? So then to come and do the very same thing in a different context, in a different case, I think is quite problematic for you.
I don't think that that's right. For one thing, Pulliam actually, if we read Pulliam, it wasn't an attack on the local rule. It was an attempt to understand the limits of the local rule. And it wasn't an attempt to, the definition of non-exempt property.
Yeah, let me give you a different hypothetical. We have a local rule that says, as you are here this morning, you have 20 minutes to argue generally each case that comes before us. Sometimes we make exceptions. Let's say an attorney walks into court one morning and says, at the end of his argument, the red light comes on, and I tell the lawyer, your time is up. And the lawyer says, respectfully, Your Honor, I don't agree with the local rule. I think it's an abridgment of my First Amendment rights. I'm going to keep talking. And I tell the lawyer again, counsel, your time is up. And he says, I'm going to keep talking. What do you think we should do with that lawyer?
Well, I think that would be contemptuous because it's within.
How is that any different from what you did here?
Not at all different, because it was very different in the sense that what Ms. Sugar did was she wanted to sell her house, which was had nothing to do with the internal working.
Right, and you told her that local rule had nothing to say about that in the face of language that says the exact opposite.
Respectively, Pulliam was a case that had to do with whether or not, if you read the Pulliam opinion, it says the mere fact that you claimed a dollar-limited exemption did not extract that residence, in Mr. Pulliam's case, from the bankruptcy estate. Pulliam never addressed 1327B, which is what we're talking about in this case, which is where Ms. Sugar had provided that the property would vest the confirmation, and it did. There's no question.
Those are all great arguments, except you didn't make them until after the fact. After you filed a motion to have the bankruptcy court validate nunc-pro-tunc the sale of the house, and then you withdrew it without giving the bankruptcy court any indication that the property had already closed.
Your Honor, respectively, the record is clear that the very day that I learned the property had been sold, my opponents were provided notice, actually within minutes of that. So the trustee and the bankruptcy administrator were very much aware of the fact that the property, and so the fact that I didn't have a very verbose withdrawal of motion, I don't know anybody who puts a lot of verbiage in that. And the reason that it wasn't nunc-pro-tunc, there's a couple of cases recently from the Supreme Court, and then from this case in the David v. King opinion that says that's not how nunc-pro-tunc works. You're not allowed to just go back and ratify something that already was done. As far as I was concerned, when the property was sold, it was a moot point. There was nothing, there was no reason to ask the court to enter the order. The timing was unfortunate, and that was, I think that was pointed out in the record, that it was very unfortunate how late in the time period that I was informed. It wouldn't have necessarily changed my analysis, but I think my disposition would have been, as Your Honor had said, better safe than sorry. Unfortunately, I didn't know until, 2 weeks after a deed had been signed. But the idea, as it relates to, that doesn't change the fact that subjectively and objectively, the local rule wasn't violated. So, that's the problem. I don't think that Polium, I don't think that one judge is allowed to issue an order that determines.
Did you say the local rule was not violated?
Correct, the local rule was not violated.
Why not?
Because the property was not non-exempt property. It was claimed as fully exempt.
Well, that's a different argument altogether. That's sort of inconsistent with what the Supreme Court's take on value versus exemption. In other words, your argument would lead to the fact that because a person has a $35,000 exemption on a $5 million home, the whole $5 million home is exempt. And that's been rejected both by the Supreme Court and by us in Reeves. But my question is, that doesn't make the local rule not applicable. Your argument was that the local rule was inapplicable because it extended to completion as opposed to some earlier state, right?
Well, my point was that it was invalid because of that.
I know it was.
But I also don't think it was applicable because what non-exempt property means was not determined by Schwab v. Riley or Reeves v. Callaway. It just simply said.
Your position just leads to a whole undermining of the exemption and the bankruptcy law and any logic or common sense. You have an exemption on real property of $35,000 under state law. And you have a $5 million condominium. And you are arguing that the $5 million condominium is exempt?
I would argue that that's partially exempt. And
No, it's totally exempt. That's your argument.
No, I think that you could take either argument. In other words,
No, I'm taking what you've taken. I'm not taking what's now. You took the position that her property was exempt.
because she had, under North Carolina law, she claimed.
$35,000 she had only.
And that was her, but North Carolina law allows to claim the valid liens as part of the consideration. So the $150,000 minus the exemption, minus the liens, all of that was exempted.
Well,
And that's different than the $5 million example that Your Honor gave.
I think it's just a blatant misreading of how to apply the exemption. It doesn't exempt property. The exemption exempts value.
I would just, again, as I pointed out in my brief, the bankruptcy code exemptions, which is what Schwab v. Riley related to, are different than the North Carolina exemptions.
Of course they are, but the concept is the same. You have an exemption for value of $35,000, and North Carolina law uses the word value.
But the difference is.
And it doesn't exempt property. In other words, simply because you have, you're electing $35,000 in respect to a real property doesn't exempt the whole property. It exempts $35,000.
I agree with that, but the issue is that.
And so if that's so, then the remainder of the property is non-exempt.
I would call that partially exempt. I wouldn't say that it's non-exempt, especially when all of the equity was covered. And the liens, unlike the bankruptcy code exemptions under 522D, North Carolina law allows you to account for the valid liens under 1601B2. That's a critical difference in terms of how Schwab v. Riley works. And also, when you look at the effect of the exemption.
What did we do in Reeves? We applied Schwab to North Carolina exemption, didn't we?
It was an unpublished decision,
I
and
said,
it was.
how did we handle it? I didn't ask you to say whether it's valid.
It didn't say that, they didn't describe what non-exempt property was. I mean, the non-exempt property is a term of art that is widely used, and it's this.
My question to you is, how did we handle, didn't we apply Schwab to the North Carolina exemption in Reeves?
You did, but you didn't say what non-exempt property was. So I think that's the difference. So, any other questions? Okay.
Thank you very much.
Thank you.
Mr. Burnett?
Good morning, Your Honors. May it please the Court, my name is Michael Burnett. I'm the Chapter 13 trustee for the Eastern District of North Carolina Raleigh Division. I'm the successor trustee to John Logan, who was the Chapter 13 trustee for the appellant's case. And today I'm arguing on behalf of myself and Brian Baer, the United States Bankruptcy Administrator for the Eastern District of North Carolina. The question before the court today is whether the bankruptcy court had authority to dismiss the debtor's case for violating a court order and a local rule, both of which were incorporated as terms.
Well, that's, I think how the bankruptcy court and the district court framed it. But as my earlier questions may have indicated, I'm somewhat concerned about the position that the debtor is in here. Because the debtor testified on several occasions. I was under the understanding my house was exempt from the bankruptcy. I asked my bankruptcy attorneys. My attorney confirmed that the house was exempt. I confirmed with Mr. Sasser, and he said that I was correct and the property was exempt, and that I could go ahead and proceed with the sale of the home. So certainly in the fraud context or the contempt context, the court is required to consider the factor of advice of counsel. And that was before the court, and I don't see that either the bankruptcy court or the district court specifically addressed that and what effect that would have on the decision to dismiss her case, particularly with prejudice.
Your Honor, that particular issue was not addressed in the initial hearing on the motion to dismiss. I believe it was discussed or raised during the subsequent sanctions hearing, and that's, Ms. Sugar is admittedly, I think it was clear.
Right, but she'd already been dismissed at that point, and there was no further sanction imposed.
Correct.
So that puts her in a pretty tough position when it comes to whether or not her initial dismissal was appropriate.
Ms. Sugar is a sympathetic individual in that respect, because she did make clear that she was proceeding on the advice of counsel. It's not entirely clear that she even understood what the terms were that she was using, but.
Can I ask you, so what sanction, did you affirmatively ask for the sanction that the bankruptcy court imposed against Ms. Sugar in this case?
The motion to dismiss filed by the trustee, I believe, did request for dismissal with prejudice, Your Honor, but nothing in addition to that, and certainly no sanctions were requested in the
So what was the
subsequent
basis for dismissal with prejudice? The fact, in your mind, that she should have known better, even given the advice of counsel?
Essentially, Your Honor, with the order and notice initially entered, with the term of the Chapter 13 plan, with the confirmation order, including the language that it did, referencing the local rule, followed by the fact that the bankruptcy administrator filed the request for a status conference in which he indicated he believed Ms. Sugar was attempting to transfer property without complying with the local rule. We believe that that was enough notice to her that something was going on, and that whatever advice she was receiving from counsel, there may be a different interpretation.
She went to closing, what, at June 14th or something like that?
Your Honor, I believe, if my recollection is correct, that the initial offer to purchase was signed in April.
Yeah, but I'm talking when she closed. She went ahead and closed on, what date?
June 14th, I believe.
Okay,
is the
now
correct-
when was the motion filed by Mr. Sasser to approve the sale?
The motion was filed with Mr. Sasser on June 10th.
All right, so she knew, presumably, of the motion to approve the sale, right?
It's my understanding that she authorized or gave Mr. Sasser permission to file the motion.
And so now there's a pending motion to approve the sale.
Correct.
And 4 days later, she goes ahead and consummates the sale.
The closing, correct, Your Honor.
Why doesn't that show some contumaciousness?
Because the motion was subsequently withdrawn.
Well, I know, but she went ahead, apparently, Mr. Sasser said he didn't know she was closing, and she went ahead on her own, knowing that they were seeking approval, and she had not yet received approval, and she went ahead and closed.
That's correct, and signed a deed in May of 2020, in May 26th of 2024.
Well, what about her testimony that Mr. Sasser suggested it may be wise to file this motion, the motion to authorize the sale, after the fact, and I was agreed just to cover the bases. I was still under the impression that the property was exempt and that I had the right to do with it what I chose without permission, all of which she got from Mr. Sasser. So my concern isn't that bankruptcy court or the district court didn't have the authority to do what it did. I think it clearly does. But there are lots of cases, I've never found any yet in the dismissal context, but certainly in the contempt, bad faith context, where when the advice of counsel defense is raised, the court is at least required to consider it as a factor and say why it is or isn't important and determinative in that case. And that didn't happen here.
Well, again, I think we're in agreement that the court has the authority to dismiss a case with prejudice for a term of years under 349A. I think the case law is clear on that. To the extent it's not, the reasons for a 5-year period versus any other period may not be expressly set forth in the order. My conclusion is that it's in order to send a message to.
Would the fact that she had more assets than necessary to take care of the creditors in the plan justify dismissal with prejudice?
Well, Your Honor, it would certainly, perhaps it would certainly give the debtor time to reorganize her finances on her own or give her creditors to pursue her.
But I mean,
estate
if
law.
she sells this and she has a premium, a pretty good premium, which would take care of I guess it would have taken care of even the unsecured creditors who had filed claims. Isn't that right?
That's correct, Your Honor.
Well, wouldn't that justify a dismissal with prejudice? If the estate had more money than necessary to satisfy creditors who made claims?
It may, Your Honor, yes. Back to my argument, there are two principal reasons why I believe the court had a reason to dismiss the case for cause, and I've mentioned several of those previously. The order and notice, the part 7.2 of the plan and the confirmation order all reference the local rule, which I don't think there's any. I don't believe there's any dispute that the debtor did not follow the local rule, and she did not tailor the local form plan as the debtor did in Trantham. In Trantham, the debtor did not like a standard provision of the plan. The court initially would not let her strike that. The debtor, of course, as this court is aware, proposed a plan conforming with the form plan and then appealed that. That did not happen in this case. So to the extent that this appeal is about the validity of the local rule, I think that question stopped the moment the confirmation order became final, because this is more of an interpretation of a term of the plan. Much ink has been spilled about the validity of the local rule, but really this is about interpreting.
Well, if it was in the plan, and I think in this case there was no objection to the plan, I think you're right. I mean, that's it. You've agreed to it. I don't think you can raise an objection after that.
At this point, no. So I think the analysis comes down to what exemptions mean or what non-exempt means in the context of the local rule, which the bankruptcy court has previously addressed in Ray Pulliam, or that particular judge for counsel for Ms. Sugar. As this court has already noted, provided a definition for that particular rule. So at this point, it's not something I think that years later we can go back and reanalyze or reconvey or reinterpret it.
Well, you can, but this isn't the way to do it. It's the way that counsel went about it in this case is not the way to revisit an objection to the rule.
And the bankruptcy court pointed that out in its dismissal order. There are other ways to be able to do that. The debtor could have, again, in the Trantham context, could have objected to confirmation and had all of this clarified. So this isn't really, at this point, this is not a question about even the court's authority to implement the local rule. Although that's a legitimate question. But in this case, the debtor and the trustee and all parties are bound by the terms of the plan under 1327. And so this is not about vesting. The local rule makes no reference to vesting. Mr. Sasser himself noted in the sanctions hearing that the local rule makes no reference to vesting. It just doesn't. That's almost a direct quote from Mr. Sasser, the joint appendix, appendix 6, page 699, starting at line 14, and he's absolutely right. The local rule makes no reference to vesting, because the local rule is not about vesting. Vesting is also, vesting is an issue that it raises so many additional questions in other contexts, and it would be helpful to have a more thorough definition of vesting.
Well, whatever the definition is, I mean, it plainly says it's still subject to section 363 and all the other provisions of the code.
And
So you just can't creatively make up vesting as some super bankruptcy exemption.
that's why I argued in my brief, Your Honor, that vesting and exemptions on their face are two different things. The exemption process is a very specific process. It requires specific forms. They're claimed at certain times. And in North Carolina, for debtors residing in North Carolina, they're based on state law. Vesting, whatever it means, happens at a different point in time, and the two on their face are not identical. And I attempted to make that point in my brief. So I agree, Your Honor.
Mr. Burnett, Mr. Sasser made several points at the beginning of his argument. At first, that he didn't think the rule was valid. Second, that even if it was valid, that he didn't think he or his client had violated it. And third, if I recall correctly, that even if there was a violation, there was no harm, no foul. Can you talk about that third point? What was there a harm? I'm not sure that that's relevant, but do you agree with that?
As an initial matter, the violation of any rule, just facially, is, I think, provides some kind of harm. Rules are in place for a reason. In this particular case, there have been a number of opinions on the bankruptcy court level as to what the purpose of the local rule is and how it's tied to other specific provisions of the bankruptcy code. One thing that's not mentioned so much, but from a trustee's perspective, I think is very relevant, is that it does implement in part section 1329. And so when a debtor, in this particular case, the debtor sold property without court authority. Now, it did not prevent me, the trustee, from filing a motion to modify. Okay, admittedly, the bankruptcy court did not go that route in this case. But
Well, the $5,000 that they paid in to try to complete the plan, what happened to that?
that money, I believe, Your Honor, was dispersed, but of course, in the argument,
To creditors.
to creditors, is my recollection. But of course, my argument, the trustee's argument at the point is that
Well, how about the extra 90 grand, whatever it was from the sale of property? What happened to that?
that I do not know, Your Honor. 94,000 approximately was received by Ms. Sugar after closing. That dwindled down to 63,000 around the time of the hearings on dismissal or sanctions. What has happened to those proceeds at this point, I do not know.
So with the dismissal, then I guess creditors would be free to go after that.
It would be. There was no stay filed pending appeal. I don't know what creditors have done between then and now. We're almost 2 years, I think, from that point. I do not know which creditors have written off the debts. Debtors perhaps could have sued her. She could have come to a resolution with those creditors on her own. I simply don't know or have the answer to that question. With respect to the final payment, which was the second point I wanted to make today, was that dismissal was not foreclosed by 1328 because the debtor did not satisfy the terms of her plan or complete payments under her plan for purposes of 1328, merely by tendering that lump sum payment. The plan payment schedule set out in a Chapter 13 plan cannot be viewed in a vacuum. It is supposed to carry out the various other portions or provisions of the Chapter 13 plan. They should. A payment schedule of so many dollars per month for so many months should pay the creditors as they are set out in the form or in the body of the plan. That's not always the case. Plans are routinely confirmed prior to confirmation, or excuse me, prior to the claims filing bar date. I believe there's 70 days for non-government creditors, 180 for government creditors. Plans are routinely confirmed before that point in time. claims are amended. Sometimes.
Well, sometimes an estate will receive, the debtor will receive an extraordinary inheritance from an uncle or something, and permits the trustee to go in and modify, right?
Yes, Your Honor, that was certainly the case in the Fourth Circuit opinion of Carroll v. Logan, or the facts of that case.
Yeah.
Also from the Eastern District, where the debtor inherited roughly $100,000, and the court in that case.
It's at 1329?
1329,
Yeah.
and the court in that case found that the inheritance was property of the bankruptcy estate, and the plan could be modified under 1329. But on your point, Your Honor, merely tendering a lump sum payment does not necessarily mean that the other terms of the plan have been satisfied. Certainly, the Fourth Circuit issued its opinion a few years ago in Plyler v. Search.
Well, the plan may become inequitable. I mean, if you have this additional inheritance, the unsecured creditors could be taken care of, and the claims are filed. I mean, there's a lot of different things that could be done. It seems to me the whole scheme is a court of equity where there are various rights, confirmation permits a certain thing to go ahead, vesting permits a certain thing, but the whole thing's not done until the whole estate is resolved and approved by the court.
That's correct, Your Honor, whether it's inheritance or, in this case, property is sold and significant proceeds are realized which are above the debtor's claim of exemptions or otherwise unanticipated.
I mean, I suppose that if they had come to court in March or April after they had that offer and asked the court to approve it all, everybody would have been delighted.
I agree with Your Honor, and I believe that the bankruptcy court attempted to make that clear in its order. The court, I think, made reference to it in the context of nunc-pro-tunc relief, but I can't imagine that Ms. Sugar would not have been granted approval. And as she is herself inserted non-standard language in her plan, which indicated in the event she did sell property, that wouldn't, she might receive proceeds, but that would not prejudice the rights of parties under 1329. That includes her, by the way. She proposed a 60-month plan, and she tendered a lump sum payment to the trustee in month 34. She had a 36-month ACP, so she didn't satisfy her applicable commitment period, and she otherwise didn't seek modification herself to reduce the plan length from 60 months to 34 months or some shorter period. And so she could have done that in this case, and the trustee could have still sought modification of the plan. That could have been heard, or she herself could have modified the plan to some other terms.
Did she ever explain why she went to closing after her attorney filed a motion for approval?
Not other than what Judge Agee, I think, has already recited from the transcript, as that she thought the property was exempt, or she had been told by her attorney that property was exempt. And so she felt as if she could do that.
And the sanctions she received, it seems to me the dismissal doesn't seem to be any punitive in any sense, because she had more money than was necessary to take care of the debtors, but the prohibition for filing for 5 years was, in a sense, punitive, wasn't it?
I would have to agree with that, Your Honor,
Yeah.
yes. So, Your Honors, if I may just conclude, I believe the bankruptcy court did, or excuse me, the debtor did not appeal confirmation of her plan, so she was bound by its terms. The local rule had previously been interpreted by the same judge presiding over Ms. Sugar's case for the same attorney in the Pulliam case. Again, that opinion was not appealed.
What did that case say with respect to the local rule?
The Pulliam case incorporated the Schwab versus Riley and Reeves versus Callaway analysis in terms of interpreting the local rule, much as the court indicated during the appellant's initial appearance here. It defined exemptions such that North Carolina is a limited dollar exemption, provides a limited dollar exemption for for homesteads, that's what's claimed. So the only thing that is exempt from the estate is the debtor's interest in that dollar amount, and that for purposes of local rule, claiming $1 of exemption as an example does not render a property non-exempt for purposes of the local rules. The local rule still applies. Now, that was a confirmation context, but the analysis should remain the same.
All right, thank you very much,
Thank
Mr.
you.
Burnett. Mr. Sasser, you've got some time for rebuttal.
Thank you. I think it's important to realize that this case is not about a debtor trying to sell property and not pay her creditors. It had to do with, the idea with the whole point of the local rule, as the judge actually said, was that the money will never go to the debtor. Well, that's actually not, that actually shows the invalidity of the local rule. In Chapter 13, whether or not it's 1306B, which is estate property, or if it's vested property, the debtor gets to have their money. It doesn't matter how liquid the money is, it doesn't matter how much the money is, it's the debtor's money. Now, the plan can be modified. And so the idea that the sale went through, which nobody had any problem with, she had a lot of money, and then the trustee filed a motion to modify the plan, which was fine. Now, we did oppose that on substantive basis. And if you look at what the judge said was, he said, you either need to capitulate to the modification and agree to the modification, give up on your substantive defenses about there hasn't been a substantial and unanticipated change of circumstance, or any of the other numerous things that were testified about and the evidence that was in there, or I'm going to sanction you. That is as substantive as it gets, and it's also against what.
But why couldn't you have said, I'm going to conditionally agree to modify the plan, but I'm reserving my right to appeal substantive questions about the bankruptcy code's interpretation? I mean, people do that all the time.
Agree to the modification. I don't know that, I mean, that would be opposed to what we were actually trying to accomplish, which is we
Right,
wanted.
but you would have reserved, say, okay, for purposes of a bankruptcy hearing today, we're going to agree that to modify the plan, but we're reserving the right, nonetheless, to appeal to the district court and then to the Fourth Circuit, our substantive interpretation.
Well, actually, that's a great question, Judge Agee. The judge actually said, you have to capitulate. In other words, I don't think he wasn't allowing the idea that somehow we would agree to it tentatively just so that he wouldn't sanction us. Or he was, no, you have to agree to this. You have to turn the money over. And we have no problem. We have said, the Murphy v. O'Donnell is very clear. The plan, vesting does not change the ability to modify. And I couldn't agree with that more. That's what the law is in this circuit. But that doesn't mean that somehow there's an escrow account where money has to sit there until the judge releases it. I mean, that's the whole point of Chapter 13 is the debtor gets to control the money. The bankruptcy judge post-confirmation just gets to either allow a modification or disallow a modification. He has no ability to exercise dominion over property, which is what he's saying. So the thing that is the grievance in this case that everybody is so upset about is actually a violation of the code itself, because the bankruptcy judge had no right to condition the sale on that. I mean, that's the difference between, if you look at how the bankruptcy code deals with sales of estate property outside the ordinary course, a notice is filed. The notice says, here's what we plan to do. We're going to sell property, use it, lease it. Let's say it's sold.
Sorry, Mr. Sasser, can I redirect you to Judge Agee's question? You just said something that the bankruptcy court had no right to do whatever it was that you weren't unhappy about. That may be right, but the question is, who gets to decide that? Does a lawyer get to decide that unilaterally by ignoring the rules of the court, or is that the remedy and appeal?
Again, I cannot reiterate enough. I do not believe that the local rule was violated. And so you're saying that, is that what the lawyer decided?
Well, the local rule, there was an order saying you cannot sell real property. An actual court order entered in this case that said during the confirmation hearing, you cannot sell real property.
So if you're referring, the confirmation order says you have to comply with ED and C, LBR G4 and G5, and that's what we're saying is that she did comply.
Let me get to my point a little bit here, is after there was notice given that she had a contract to sell, and the administrator found out about that, he filed a motion for a status conference in which he said that the closing may be imminent, and the docket does not reflect that the debtor filed a motion to the court seeking permission, and we want a status conference. That was before the closing and before you filed your motion for approval. But that clearly was a meeting intended to question whether she could go ahead, and that notice was sent to her personally. And that was on the 9th. And on the 14th, she went ahead and closed without going to that hearing or having the benefit of that hearing or having some discussion which questioned it. Now, and then you, the very next day, you did file a motion for approval, and I presume she had a copy of that.
If you read what that motion says, though, it says, and it was just done.
I know, but the point is, at that point, both the administrator and you were deferring to the court and saying we want a decision because the administrator has raised the question whether it should be permitted. And she received notice, actual notice of both of those, and she decided to go ahead. Now, I'm just questioning where her involvement is not, you didn't tell her to go ahead and close, did you?
I mean, I know, but I mean, the idea is.
You know this notice on the 9th.
Yes, but Judge, here's the thing. The bankruptcy plan itself says that she got to keep all the net proceeds of sale.
I don't care if it's right or wrong, you're arguing the merits. I'm suggesting to you on the 9th, the administrator put everybody on notice saying that he believed that the court should have reviewed the thing and there should be permission granted. Right. He made this notice and said, we're going to have a meeting to discuss this with the court. You then followed up to be safe. You filed a motion the very next day. She got copies of both of those things, and then she went ahead without, I gather, without your knowledge. Is that right?
I think the record is, it was very subtle.
Sir, can you answer my question? Did she go ahead without your knowledge?
Right, I found out, she sent me a closing statement and said, hey, I had closed. But I don't think that the issue is, the bankruptcy administrator can file any motion he wants. He's just the bankruptcy administrator.
Look, you're missing my questions. I just need the answers. My answer was she had notice of the administrator's concern about her sale. And they wanted to have the court to hear it and to get permission. It says the docket does not reflect that the debtor has filed a motion seeking permission to sell this. And she got a copy of that. And then you filed the very next day a motion to get approval. And then without your knowledge, she goes ahead and sells.
Well, that is what happened, but basically, the thing about it is, she had every right to sell. It was her property.
Well, she may or may not have.
It vested in her, it wasn't non-exempt property, and the plan itself said, there's a non-standard provision in there that said she has to keep all the money. So
she's not entitled to make that decision herself. She has to have the court make the decision, especially when the administrator objected, and you then followed up and filed a motion. She personally made a decision that she could go ahead and sell despite the fact that, number one, the administrator objected, and number two, you filed a motion to comply. And the motion, both of those were pending.
That doesn't answer the question, though.
It answers the question of whether she is entitled to sanctions.
Well, I would like the question answered of, was she entitled to sell, which she was? And she was, and even
well, that depends on whether the property's exempt. And I respectfully suggest that Reeves took care of that. I mean, you should have known that.
I don't.
The property is not exempt. It's the value of $35,000 is exempt. And you just conceded here today that the property was not exempt, it's just partially exempt.
I said that in the context of the $5 million house, but Your Honor.
Well, this is a $150,000 house or $222,000 house.
In Pulliam, the trustee himself admitted it wasn't clear, and there's another Eastern District bankruptcy judge who's now retired who said it's ambiguous and it's not clear. So
what's wrong with going to the court and having it resolved when everybody's objecting to your position?
I don't know that everybody is objecting to my position. In fact, Pulliam all had to do with whether or not it's property of the estate or not. And I mean, that's where the Trantham opinion is very critical because it's not property of the bankruptcy estate. And we're talking about how the plan somehow bound Ms. Sugar, it binds them too. And you talk about ambiguous rules, I mean, those are construed against the drafter. All this ambiguity and the reason these forms.
But you knew the bankruptcy court's position. You knew it from the Pulliam case.
No.
And you went ahead, according to the court, you were fighting that position, and you were carrying on your fight based on your own decision as opposed to having appealing the court's decision.
I just disagree with that.
I know, that's what the court found.
Well, the court can't read minds. I mean, the court can make its best judgment. I think what the judge is saying is, because I ruled, that is the rule forever, all time.
It is until it's appealed and
It's
reversed.
one single opinion, and it didn't even address 1327A. If it had addressed 1327, B, if it had dealt with vesting, I think there would be a different argument. If Pulliam had said, when property vests at confirmation, it means nothing. It's still, but what we're talking about is the code itself, and what the plan says is it vested. It's not part of the estate. She can use, sell, or lease that as she sees fit.
Well, I thought 1329 indicates it still is part of the estate and can be subjected to different conditions and provisions based on changed circumstances.
It doesn't mean it's part of the estate. What it means is that a plan can be modified, and I'm agreeing with that, and that's what happened, and we opposed it on its substance. That's why we had a large.
I understand. You're missing my whole point. You have arguments to make on these things, and you made them, and yet you didn't go through and get permission when you knew the court was in a different position than you. The court disagreed with you.
I didn't know that, but I would.
Oh, you didn't know that?
I did not believe the local rule was being violated. And I'll just say this: what difference would it make if $94,000 was in my IOLTA account, or whether or not she had $62,000 in her savings account? Which is, by the way, her having the money is what the bankruptcy code actually says. What would it matter?
Because there's an orderly arrangement under the code, and if the exemption is $35,000, it doesn't exempt the entire property, and the exemption is not framed in terms of property having at least $35,000. It exempts $35,000, and she had property worth $222,000.
But what you're describing is a Chapter 7 concept. This is Chapter 13 bankruptcy. The debtor gets to keep all their money. There is no attorney escrow account in the
Well, you
bankruptcy
can
code.
argue that, but I think
Well, it's true.
You've got Schwab and you've got Reeves.
Schwab never says that money must go into an attorney's trust account so that the judge will then
No,
have
it talks about the scope of an exemption and how to apply an exemption.
But that's why it's such a non sequitur. The local rule makes no sense, which is why they changed it. I mean, that kind of tells you something, doesn't it? The whole idea of non-exempt property actually made no sense. It was poorly written, and it was ambiguous, and that's been agreed to. We shouldn't be getting sanctioned for ambiguous provisions, which I think even my opponent would concede that. In fact, they are the ones who said in Pulliam, we don't know what this means. And so the idea.
Well, let me ask you this. I just go back. You know, what I'm really troubled by, I hear your arguments, and they're probably legitimate arguments, but they're procedures for addressing them. In this case, we had a big red alert flag raised. The trustee said, I heard the property is being sold without permission of the court. Now, your reaction now in court today is say, we didn't have to get permission. But that isn't the point. The point is the trustee said, we need to go to court to decide that. And then you followed up to be safe and filed a motion. And so now you have this red alert filed by the trustee said we need to go to court. You filed a motion for safety to preserve your position, and then she goes ahead and closes.
Which was harmless, because
it doesn't matter whether it's harmless. She denied, the trustee thought you needed to get permission, and she didn't have permission.
well, it was actually the bankruptcy administrator, and the bankruptcy administrator was just simply wrong. He was
That isn't
wrong.
the issue. The issue is there's a process. There was a hearing scheduled, going to be scheduled. It was scheduled.
And
It was
I would-
immediately scheduled before she sold.
I would say the same thing about modification of the plan. There's no, I think the way that I'm sort of hearing this is the property is sold and then the money goes right to the trustee for disbursement. And that's not what the code and the rules say. The code says if you want to file a modification, you have to carry your burden under 1329. There's a rule provision, 3015. They actually file that. That's how this works. The money doesn't just go to the trustee. There's a sale and that goes through, and then after that, parties and interests can file motions to modify. There was no harm done to anybody in this case by the virtue of her selling the property. I mean, that to me is the real kind of tragedy about it. There is no harm done. There was no reason to dismiss the case with prejudice. What the judge should have done is just allow the modification, and then she could have chosen to either pay it or not to pay it, and that's what all Chapter 13 debtors have, that same option.
All right, thank you, Mr. Sasser.
Thank you.
The case is submitted. We'll come down and greet counsel and adjourn for the week.
This honorable court stands adjourned. Sine die, God save the United States and this honorable court.